Picture the Lower East Side of Manhattan in the final days of 1907. Winter has settled between the tenements. The streets are crowded with pushcarts, children, delivery wagons, factory workers, and families packed into buildings that were already among the most crowded residential blocks on Earth. New York is struggling through the aftermath of the Panic of 1907. Factories have cut hours. Thousands of workers have lost jobs. Money is tight. And then, in apartment buildings across the neighborhood, tenants learn that their rents are going up. For a family already living from one weekly envelope of wages to the next, the increase is not an inconvenience. It can mean losing the apartment. A young garment worker named Pauline Newman helps organize women throughout the neighborhood. Hundreds of working women go from building to building asking families to refuse the increases. By late December, the protest has grown into a massive rent strike involving thousands of tenants. Newspapers describe something almost unheard of in American housing. Renters acting together as though they were workers confronting an employer. Their message is simple: lower the rent or we will not pay. And that demand carried enormous risk, because refusing to pay rent in 1907 was not remotely the same calculation it would become under later tenant law. A landlord could begin a summary proceeding to recover possession. A court could issue an order. A marshal could remove the occupants. Furniture could end up on the sidewalk. Families who resisted sometimes faced police at demonstrations. And once you were out, there was no public housing authority waiting with another apartment, no modern rental assistance system, and no broad network of legal services devoted to keeping tenants housed. You might squeeze into the rooms of relatives. You might rent space from another family. A charity might help temporarily, or you might simply join the enormous population moving from one overcrowded building to another, carrying everything you owned in a cart. So could an American landlord before modern tenant rights simply throw you out overnight? Not always. That distinction matters. Eviction procedures existed long before modern tenant protections, and in many places, an owner could not legally walk into an occupied apartment, grab the tenant by the collar, and dump the family into the street without consequence. Courts, notices, sheriffs, constables, marshals, and local rules had existed in various forms for generations, but those procedures mostly answered a different question. They asked whether the landlord had the legal right to possession. They did not necessarily ask whether the rent increase was fair, whether the apartment was safe, whether the landlord had repaired the roof, whether the tenant had children, whether moving would cause hardship, or whether anyone could realistically find another home. The machinery of law existed. What was missing was the thick layer of rights that modern renters instinctively assume sits between losing an argument with a landlord and losing the roof over their heads. To understand how different that world was, you have to forget the modern idea that renting a home automatically creates a package of consumer protections. For much of Anglo-American legal history, a residential lease was treated primarily as a transfer of an interest in property. The landlord gave the tenant possession for a period of time. The tenant promised rent. If the agreement did not specifically require the landlord to perform some additional duty, courts were often reluctant to invent one. This made sense in the older world from which the rules had developed, a world in which leases frequently concerned farms and land rather than urban apartments. If a farmer leased acreage, the value was partly in the land itself, and the tenant was expected to manage much of what happened on it. Then America industrialized, and the same legal assumptions followed millions of people into crowded apartment buildings. That created a strange result. A family could rent rooms with leaking ceilings, broken stairs, inadequate ventilation, defective plumbing, or dangerous sanitation, and still face an obligation to pay rent. In 1887, the United States Supreme Court summarized the traditional common law rule in Viterbo versus Friedlander. Under that older doctrine, a landlord was generally under no implied promise to repair the property or even to guarantee that it was fit for the particular purpose for which it had been rented, unless the agreement said otherwise. The rule sounds astonishing when applied to a tenement apartment, but that is because it had not originally been designed around the modern tenant as a housing consumer. It had grown out of a very different conception of land. In practice, poor renters had another problem. Many did not have elaborate written leases at all. Working-class urban housing often ran through short agreements, oral arrangements, monthly payments, subleases, lodgers, and rooms rented inside apartments, already rented by somebody else. Families took in boarders because the boarder's payment helped cover the rent. A widow might rent a bed to a factory worker. A family might divide 3 rooms among parents, children, and unrelated lodgers because the mathematics required it. At the Tenement Museum's building at 97 Orchard Street, census records show that 110 people lived in 22 apartments in 1900. The apartments were small. Across the Lower East Side, it was entirely possible for a large family to occupy only a few hundred square feet. That crowding was not simply the result of landlords stuffing people into buildings for profit, although exploitation certainly occurred. It was also the result of extraordinary demand. New York's population was exploding. Immigrants arrived by the hundreds of thousands. Factory work was concentrated near dense neighborhoods. Public transportation had not yet made every outer neighborhood an easy commute. Families wanted to live near jobs, relatives, synagogues, churches, markets, and people who spoke their language. The poorest renters competed for the cheapest rooms in precisely the areas where space was already scarce. And scarcity gives power to whoever controls the thing everyone needs. A tenant could complain about a cracked wall, but if 10 other families were willing to take the apartment, the complaint carried limited leverage. A renter could threaten to leave, but leaving might mean paying a mover, losing access to nearby work, moving children, and somehow producing money for another landlord. The market theoretically gave tenants the freedom to choose. Poverty made that freedom much less impressive. New York even developed an extraordinary ritual around this instability. For much of the 19th century, the 1st of May became known as Moving Day. Under an old New York arrangement, large numbers of leases expired at roughly the same time. Landlords announced new terms. Families decided whether they could stay, and on the 1st of May, the streets filled with carts carrying beds, tables, trunks, chairs, and every other possession a household could move. Thousands of households could be changing addresses at once. Movers charged heavily because demand for wagons exploded on the same day. Streets clogged with furniture. A person could spend years in the same city while repeatedly rebuilding home a few blocks at a time. Imagine what that does to the meaning of the word home. Today, people often think of renting and owning as different financial arrangements involving the same basic object. Back then, the psychological difference could be much larger. Ownership gave a family a claim on permanence. Renting often meant that your continued presence depended on a contract with an expiration date, a landlord's willingness to renew it, and your ability to meet whatever price came next. Still, landlords were not one uniform class of wealthy men counting rent money in distant offices. New York certainly had major property owners and speculative investors, but it also had small landlords whose savings were tied up in one building. Some lived in the same property as their tenants. Their expenses did not disappear when a tenant lost work. Property taxes still came due. Mortgage payments still came due. Coal had to be purchased. Plumbing failed. Roofs leaked. Janitors expected wages. A building with several non-paying apartments could become a financial crisis for the owner as well as the tenants. That tension is important because of the history of tenant protection makes very little sense if every landlord is reduced to a cartoon villain. Housing is expensive to build and expensive to maintain. When costs rise faster than rent, an owner eventually has a real problem. But the reverse is also true. When housing becomes scarce enough that owners can raise rents without improving the building, tenants have a real problem. And before strong regulation, the side controlling the property usually entered that negotiation with considerably more power. The weakness of the old arrangement became especially visible inside tenements. New York's first major Tenement House Act was passed in 1867. The city was already discovering that unrestricted density created consequences that could not be contained inside private contracts. Disease spread beyond individual apartments. Fires crossed property lines. Waste entered shared streets and water systems. Unsafe housing was becoming a public problem. The 1867 law attempted to require things such as ventilation, sanitation, and fire protection. But early housing regulation was filled with loopholes and enforcement problems. One famous weakness was the requirement that rooms have windows without initially making clear enough that the windows needed useful access to outside light and air. Builders could satisfy rules on paper while producing interiors that remained dark. Another Tenement House Act followed in 1879. It helped create the notorious dumbbell tenement, a narrow building pinched by small air shafts intended to bring light and ventilation into interior rooms. On architectural drawings, the shafts looked like an improvement. In reality, many became narrow vertical pockets that collected garbage, odors, noise, and smoke. The city had discovered something governments repeatedly discover when regulating housing. Writing a minimum standard is easier than producing good housing. Then came the Tenement House Act of 1901, the so-called New Law. It imposed far more serious requirements on new tenement construction, including larger spaces for light and air, improved sanitation, and stronger fire protections. Reformers celebrated it, and it genuinely improved standards for new buildings. But every improvement carried a difficult economic fact. Safer buildings generally cost more to construct than dangerous ones. That meant housing reform could produce an uncomfortable short-term effect. If new construction became more expensive while immigration and population continued rising, the supply of cheap apartments could tighten. Owners of existing buildings suddenly possessed something more valuable. Tenants gained better safety rules, but the competition for affordable rooms did not disappear. The 1907 rent strike emerged inside exactly that contradiction. The panic of 1907 weakened wages and employment just as renters faced higher housing costs. Pauline Newman and other organizers approached the problem using techniques workers already understood from factories. One worker refusing an employer could be replaced. Hundreds refusing together created leverage. One tenant refusing a rent increase could be evicted. An entire building refusing created a logistical and political problem. Women were especially important to these early tenant movements because they often managed the household budget. They knew exactly what rent was doing to food money. They knew which child needed shoes, how much coal remained, what the grocer was owed, and how many hours of sewing were required to cover the landlord's increase. The rent strike transformed those private calculations into collective action. Tenants also began weaponizing the new housing codes. If landlords wanted the courts to enforce rent obligations, organizers could ask city inspectors to enforce building obligations. Strike committees gathered complaints about unsafe conditions. Officials from city departments suddenly faced pressure to inspect buildings that might previously have received little attention. It was a major conceptual shift. The apartment was no longer being treated only as private property governed by agreement. Tenants were beginning to argue that the condition of a rented home involved public rights. But the 1907 strike did not create modern tenant law overnight. Many participants lost. Eviction proceedings moved forward. Police confronted demonstrators. The movement eventually faded. Some tenants obtained reductions, but there was no permanent system fixing rents or guaranteeing renewal. What it did create was a memory. That memory became much more important after the First World War. During the war, residential construction in New York slowed sharply. Materials and labor were pulled toward wartime priorities. Immigration patterns changed. Then soldiers returned, households formed, economic activity surged, and people competed for a housing stock that had not expanded fast enough. The basic arithmetic was brutal. More households wanted apartments than the city had reasonably priced apartments available. Landlords saw market rents rise. Tenants saw what looked like profiteering. And again, both realities could exist simultaneously. A landlord facing higher coal prices, maintenance costs, taxes, and mortgage expenses could legitimately need more rent. But a landlord sitting on a scarce apartment could also demand an increase simply because someone else would pay it. The housing shortage made it difficult to distinguish necessary increases from opportunistic ones through the market alone, because desperate families would agree to almost anything rather than become homeless. Rent strikes spread again during the years around 1918, 1919, and 1920. This time, they were larger and more politically dangerous. Tens of thousands of tenants organized. Newspapers reported huge meetings. Tenant associations demanded protection from sudden increases. Landlord organizations argued that restrictions would punish property owners, discourage construction, and make the shortage worse. The argument should sound familiar because almost every generation since has repeated some version of it. Tenants said housing was too essential to be governed entirely by bargaining power during an emergency. Owners said housing could not exist if government separated rents from the real cost and risk of providing it. Both claims contained truth. The problem was that families were being asked to settle the economic debate while their furniture was being carried toward the sidewalk. By 1920, New York lawmakers decided that ordinary property law was no longer sufficient for an extraordinary housing shortage. A series of emergency rent laws represented one of the most dramatic revisions of the landlord-tenant relationship in the state's history. Courts were given authority to examine whether demanded rents were unjust, unreasonable, or oppressive. Restrictions were placed on certain evictions. Instead of assuming that the expiration of the private agreement automatically ended the tenant's claim to remain, the law created circumstances in which occupancy itself received legal protection. That was revolutionary. For generations, the basic logic had been that the owner's property right came first, and the tenant's protection came mainly from the contract. Now the state was saying that in a housing emergency, possession of a home could create interests that the owner could not simply erase by writing a new price on a lease or announcing that the term was over. Property owners challenged the laws almost immediately. One of the major cases reached the United States Supreme Court as Marcus Brown Holding Company versus Feldman. In 1921, the court upheld New York's emergency restrictions. The justices accepted the state's argument that an extreme housing shortage could justify temporary limits on rents and evictions under the government's police power. Think about how far the law had moved. Only a few decades earlier, the dominant legal tradition could say that a landlord had no implied responsibility even to guarantee that leased property was suitable for its intended purpose. Now, the country's highest court was allowing government to tell an owner that because housing conditions become a public emergency, the owner could not exercise every traditional property remedy in the old way. The change did not mean tenants suddenly controlled their apartments. They still owed rent. Owners could still recover possession under specified circumstances. Courts still processed disputes. The landlords could argue that proposed rents were reasonable. The state had not abolished private property. What changed was the balance. And once that balance could change, the entire philosophy of renting began to change with it. The older system had treated most housing disputes as variations of contract and property law. The emerging system increasingly treated housing as something with consequences for health, labor, family stability, and public order. A dangerous staircase was no longer only a defect the tenant should have noticed before renting. It could become a code violation. Lack of heat could become a government concern. Overcrowding could become a health issue. Retaliation against complaining tenants could eventually become regulated. The physical condition of an apartment could eventually affect what rent was legally owed. This transformation unfolded slowly and unevenly across the country. There was never one day when America suddenly acquired tenant rights. Different cities and states moved at different speeds. New York became unusually aggressive because its density and housing crises made the old system particularly difficult to maintain. And even New York retreated at times. The emergency rent system created in 1920 was temporary. The major emergency controls eventually expired in 1929 after years of political battles and court challenges. Real estate interests argued that regulation discouraged new construction. Tenant groups warned that removing protections would return bargaining power to owners. Then, the Great Depression rearranged the housing problem again. Millions struggled not with rapidly rising rents, but with unemployment and inability to pay almost any rent at all. Landlords struggled to collect enough income to pay mortgages and taxes. Buildings went into foreclosure. Cities struggled with declining revenue. The housing market demonstrated another uncomfortable truth. When tenants collapse financially, landlords can collapse with them. Company housing revealed the same dependency even more clearly. The most famous example had already appeared in Pullman, Illinois, during the 19th century. George Pullman built a model industrial town south of Chicago for workers manufacturing his railroad cars. The town was cleaner and more carefully planned than many industrial neighborhoods of the era. Pullman believed that attractive housing and orderly surroundings could create a more stable workforce, but the employer was also the landlord. When the Panic of 1893 damaged the business, the company reduced jobs and wages. Housing rents did not fall proportionately. Workers could therefore experience a wage cut from the same economic institution that still expected the housing payment. National Park Service records show how severe some wage declines became. Seamstresses, whose monthly earnings had been nearly $40 before the downturn, could be making little more than $22 by the spring of 1894. The rent was not merely another bill, it was part of the power relationship at work. The Pullman strike that followed became a national labor crisis. The housing dispute was not the only cause, but the refusal to reduce rents while wages fell became one of the workers' central grievances. It illustrated the most extreme version of rental insecurity. The person controlling whether you earned money could also control the place where you slept. Most American tenants did not live in company towns. But the underlying problem was similar. Shelter is not an ordinary purchase. If the price of a shirt rises, you can delay buying the shirt. If the price of your home rises beyond what you can afford, the transaction ends with you physically leaving a place around which your life has been organized. That is why charities became part of the old housing system, even though they were not technically part of landlord-tenant law. Religious organizations, settlement houses, ethnic benevolent societies, and private charities sometimes helped families with rent, coal, food, or temporary shelter. But assistance was inconsistent and often depended on judgments about who was deserving. There was no general guarantee that a family facing eviction would be rescued. City officials operated under similar limits. A housing inspector might document dangerous conditions, but closing a building created another problem. Where would the occupants go? Strict enforcement could make unsafe apartments illegal without creating safe apartments to replace them. Reformers repeatedly discovered that a housing code without housing supply could protect people on paper while displacing them in practice. That is one reason the story cannot be reduced to good tenants defeating bad landlords. The deeper conflict was structural. Industrial cities had created enormous populations of people who needed to rent close to work. Private builders had to earn returns on the money invested in housing. Governments wanted healthier buildings but were reluctant to build housing themselves. Owners wanted control over property they had purchased. Tenants wanted security in homes around which they had built their lives. Courts inherited doctrines created for an earlier economy and tried to apply them to tenements filled with factory workers. Something had to give. Over the 20th century, more and more of the risk that had once rested almost entirely on the tenant was redistributed. Housing codes strengthened. Rent regulation appeared during emergencies. Public housing created a government role in supplying apartments. Later generations of law expanded requirements for heat, sanitation, maintenance, notice, and legal process. New York eventually adopted a statutory warranty of habitability, formally embedding the principle that a residential landlord is not merely delivering possession of space. The rented home itself has to meet basic standards of human habitation. That idea would have sounded radical under the older common law rule. It now sounds almost obvious, and that may be the most revealing part of this history. Tenant rights are easy to mistake for natural features of renting because the generations who fought for them are mostly gone. The requirement that an apartment be habitable feels self-evident. The idea that an owner should follow a defined legal process before removing a family feels self-evident. The idea that reporting dangerous conditions should not automatically cost you your home feels self-evident. None of it was self-evident. It had to be built. It was built out of overcrowded tenements, where families learned that individual complaints accomplished very little. It was built out of women walking from apartment to apartment during the winter of 1907. It was built out of housing inspectors carrying lists of violations. It was built out of landlords arguing that regulations could destroy the economics of rental housing. It was built out of judges trying to decide where private property ended and public necessity began. It was built out of families whose furniture actually did end up on sidewalks. So, could a landlord throw you out overnight before modern tenant rights? The precise legal answer depended on the place, the agreement, and the period. Even in the 19th century, eviction could involve formal procedures. Owners did not possess an unlimited legal right to use violence whenever they wanted possession, but the practical answer is still unsettling. A rented home often provided far less security than Americans now associate with the word home. Your landlord could raise the rent when the agreement allowed it. Your short tenancy could end. A new lease might never be offered. Serious defects might not release you from the obligation to pay. Losing work could quickly become losing housing. Complaining could be dangerous when another family was waiting for the apartment. And once the legal right to possession shifted back to the owner, society offered surprisingly little protection against the consequences. The renter had shelter. The owner had property. And for a very long time, American law understood those as two very different kinds of power. The rent strikes and housing laws of the early 20th century began changing that equation by introducing a new idea, that living somewhere creates interests of its own. Not ownership, but stability. Not permanent possession, but process. Not a right to free housing, but a recognition that the relationship between landlord and tenant is not exactly equal when one side's bargaining chip is money and the other side's bargaining chip is the place where they sleep. That recognition is the foundation underneath much of modern tenant law. And it began, in part, in places like the Lower East Side, where families crowded into tiny apartments and discovered that the only thing more frightening than refusing a rent increase was accepting every increase forever. In the winter of 1907, thousands of those families made a calculation. Individually, they could be replaced. Together, they might be heard. Many were still evicted. Many demands failed. The strike did not immediately transform the law, but something fundamental had changed. The rented apartment was beginning to become more than someone else's property. It was becoming somebody's home.